Hola, ¿ya me escuchan?
Yes.
Perfect. Okay. Let me then. Okay. Let me share the. Okay. Can you see this presentation?
No. No.
No.
No? Okay. Let me see. Okay. Okay. Now you can see it, right?
Sí.
Okay. Perfect. Well, I want to. I have another presentation. How many of you do rentals?
No.
None of you? Okay. Well, I want to give you I want to talk about the rentals and lodging services. I see a lot of people that have many concerns or many uh, controversies with the rentals, and I want to provide you like a very general basis for the rentals. And okay, let me. As you know, a lease agreement, it is agreement between landlords and tenant, whereby the landlord grants the tenant the right to use and enjoy a real property in exchange for a fixed agree upon payment. So the agreement, the rental implies a person who grants the possession to the other party for the use of this property in return of an exchange of a money. The characteristics of the lease agreement is to transfer the use of the possession. It is a principal contract because it doesn't depend of another contract. It is independent or not subordinated to any other contract. It is bilateral because it's involved mutual obligations and right to the parties. It is onerous because it involves mutual, both parties receive a benefit. One of them receive a monetary benefit. It is consensual because it is formed through mutual consent of the parties involved. It is formal because each time that the rental it is about properties, it must be written. It is commutative because the benefits of the obligation are known and balanced since the very beginning. Who can lease the contract? Anyone who has full ownership and free disposal of the property. Also, the one who is legitimate or authorized by a person who has the possession and or expressly authorized by law. These facts that I'm telling you right now is to understand between a lodging service, between a rental agreement. I think it's very necessary for you to know these facts because when you face certain kinds of problem or when you want to deal with a rental, you could either, instead of renting a property, doing a lodging service. It is very similar, but at the end there's one difference between one and the other and could help you to prevent any conflict in the future. You were telling me that it is very common there in Chapala that the owners don't want to reimburse the money, or it is also common in Chapala that people that rent a property for any if maybe they don't have the money to pay, they're just going to stay in the property, and until there's a judicial sentence they will go out. But in the meantime you cannot take him out of the property or evict him without any sentence. Have you faced this kind, or are you aware of any these kinds of matters that happens? Okay, what can I rent? You can lease any goods or properties that can be used without being consumed upon the first use, except for the prohibited by law and personality rights, which cannot be subject to lease. The obligation of the landlord regarding to the article of Jalisco is to transfer the right of the use of temporary enjoyment of the leased property. Since you're granting the transmission of the right since the very beginning of this usage, there's no way for people, even though they don't fulfill the contract, to take them away from the property that you already grant by a contract. This means that if you grant the possession of a property, it has to be delivered back the same way that it was transferred. So if there's not any formal way for you to prove that the property has been handled back, and you come into the property without having a document establishing that the property was already delivered, you can get into a very deep criminal problem. What are the obligations of the landlord? To transmit the right or use of the property in judgment, to carry out necessary repairs, to refrain from interfering in any way with the tenant use of the leased property, to guarantee the peaceful use of enjoyment of the property for the entire duration of the lease, to be liable for damage suffered by the tenant due to hidden defects or vices that exist before the lease, to be liable for damage if the tenant loses the property as a result of the landlord being evicted from it, to return any balance in favor of the tenant upon termination of lease contract, and to provide the tenants with documentation that proves the payments of the rent. The obligation of the tenant is to pay the agreed rent, to be liable for any damage, to use the property strictly for the agreed purpose, to promptly notify the landlord of any usurpation, harmful act, or threat to the property by the third party, to vacate the property once the lease term has expired, either by contract or by law. That's why it's very necessary when the lease already expired to have a document evidencing that the property was delivered back to the owner. If you don't have this letter of this constancy of delivering back the property, you can get into a criminal problem. So it is very necessary to have a documentation establishing that the property was already being delivered to the owner. The lease agreement for real estate must always be in writing. What does a lease agreement must include with the following elements? Full name of the landlord and full name of the tenant, a detailed description of the property being leased, a list of installation and accessories available for the tenants used with the leased property, the current condition of the property. I suggest when you have the current conditions established in the contract, try always to attach a photograph inventory so that you can prove the way that it was given the property, and when it's delivered back the property, establish that it's in the same condition as as it has to be returned. What happens if you establish in the contract that when the lessor gives back the property the way it should be? If you establish that the property has to be delivered back already painted, it is mandatory for the tenant to give back the property painted. If it was not established, then you cannot obligate him to give back the property rented. Is there any doubt about rentals?
How is the requirement to receive a letter when you return the apartment or house back to the owner? I have never ever received a letter indicating that the property has been returned. Is that common, new?
It depends. I mean, if everything went 100% good for people, as you said that you haven't seen in your practice, it is okay. But at least if you have any WhatsApp or a message that the property has been already delivered, or you have witnesses, then it is just like a good practice to have this documentation evidencing that the property has been delivered back. The problem comes when a conflict arises between any of the parties, and since the person didn't give you in a formal way or by writing the deliver of the property, and you just enter to the property, it can be in a matter of time be very, very it can, I mean, it can be, or it can get complicated, because usually bad tenants, when they don't fulfill the contract, and you try to evict them or just take the property, and you don't have any document that establish that the property has been returned, they could demand you in a criminal way, saying that you trespass the property when you have a contract. At least you make sure to have any evidence of the tenant giving you back the property, or establishing that by the time that you receive the property, establish the condition that you receive the property. Other way, yes.
So in other words, I have one rental. So what I did when the people moved out is I did a walkthrough with them and a checkoff list to check all the property. And then they returned the keys, and I put on the checkoff list, they returned 2 sets of keys. They initial signed and dated it, and I initial signed and dated. So that is kind of what you're saying. That's proof
Yes.
that they returned the property.
Yes, yes, and you establish. See, I mean, this is very useful, and it is a good practice to do what you just mentioned, because if any happens, or any conflict that might arise in the future, you have evidence that you received the property and on what conditions was the property. Since a security deposit must be returned days later, it could might arise a conflict, which could be addressed in the courthouse. If you don't have any document establishing that the property was already delivered, in this same example that we're discussing, imagine that the property was not the contract was not already finished. Imagine that the person wants to give you back the property without fulfilling the duration of the contract, but there was not any agreement canceling the contract, and you just enter to the property and rent it to another person without canceling the contract that you currently have, it might get you into trouble. That's why always is very advisable to subscribe another document canceling the previous contract so that you can dispose of the property again and rent to a third party later.
Okay, I was actually asking more from a renter's perspective that you can't force your landlord to give you anything that says you return the property. Most of them think that the deposit belongs to them. The problem seems to be with education with regards to the landlords themselves, renting them out, that many actually believe that the security deposit is theirs. And I've never been successful in obtaining any kind of confirmation that I have vacated the premises in good condition as is was. And so I was more asking from a renter's perspective, because most landlords that I've dealt with have no idea about any of this and have their own set of beliefs, i.e. regarding deposits, all kinds of things. I would say about 90% of landlords here don't return your security deposit and believe that they have no need to do so. So it's just,
Okay.
yeah, coming from the other perspective, most landlords don't adhere to any of this, none. So I get the procedure, and it's good as from a renting perspective, but as a renter, doesn't match the reality. So that was my
Okay.
question.
Okay, this reality that it happens in Chapala is way different than the reality here in Guadalajara. I'm gonna tell you why. Most of the I don't know if these rentals talking about the landlords, are they most foreign people? I mean, not Mexicans, or are also Mexicans?
About 90% of my landlords, 95% have been Mexican.
And these Mexican don't refund or reimburse the security deposit.
No.
Okay, why am I telling you this? Here in Guadalajara, it's very different the perspective. Why? Because usually tenants request for the deposit. Either they just as a bad usage, they just don't pay the last month rent, and they just try to deduct their security deposit about the last month rent. I don't think it has to be that way, but tenants that have happened this matter before, that the owner didn't give them the deposit back, they usually do this. Or what they pressure is, okay, if you're not gonna give me the deposit, then I'm just gonna keep in the property until my deposit is being fulfilled. What happens, or why the tenant do this as a leverage? Because if a tenant stop paying, the owner cannot come into the property until the tenant return the possession of the property. In the meantime, the owner cannot restrict the service or cut the electricity or the water, because if they do so, they can go to court, stop paying, and it can take a lot of time to come into a solution, and the tenant is gonna be using the property without paying. I'm not saying that at the end he will have to pay, but I mean, owners are not willing to go into court with the lack of certainty that they could be having the money that for the renting property. I don't know if I explain myself.
I understand. I do. Thank you. Thank you. That does help.
Okay.
The only other option I know of in those types of cases, because most landlords here don't adhere to any of these regulations, really. And the only other thing I've, in really hard situations, was to tell them that you'll check with SAT about whether they're declaring the rental income, and then you get your deposit back all of a sudden. That's the only other thing I've.
So you use that as a way of pressure. Okay, so if you won't return me the money, I'm going to the SAT and will tell you that I will prove that I was renting you, that you receive a money and you didn't pay your taxes?
Well, sometimes, if nobody wants to play by the law, there's not much else you can do. But anyway, sorry, I'm getting sidetracked. So thank you. Appreciate the explanation.
Okay, what I'm trying to explain is, I mean, I know the way it works there. In fact, I have an issue 2 months ago where I was representing a tenant and tried to get in touch to the owner and try to set everything so that by the time the contract elapsed, the owner had the certainty that the property was going to be delivered in good shape or better shape than the way that it was at first transmit. And everything seems to be very good. The owner accept. We did a walking through. I sent her a video, and all of a sudden, once she received the property, she said, or she just invented that the water machine didn't work, and I mean, I saw the property. I did a video. I sent it to her, and everything was fine. And somehow she find a way to not refund the money to the tenant. We could do many things because we didn't have any document establishing that the property was already delivered. She could just rent it to another person without having this document that I'm telling you about to have evidence that the property was already delivered. At the end of the day, the tenant didn't want to go more or to invest good money or bad money. But yes, I'm aware it is a common practice for owners to keep the deposit and feel that this security deposit it belongs to them when it was just to warrant that the property is gonna be used and it's just gonna have the normal tear and wear upon the time.
Yeah, some of them actually believe these things. There does actually seem to need to be a campaign of education for people who are renting out apartments or houses, because I've had people argue with me till the end of the day that security deposit is theirs, that it's not supposed to be returned. It's the cost of renting. So it does seem to be just a point that a lot of education is needed, not just for real estate agents, but private individuals renting out their property. But
Yes, I agree. And somehow, since they hire a real estate company to help for finding the right person, most of the time they say, "Well, I already paid the commission, so the security deposit was transmit to them." When it is different, a finder's fee for something that you hire me to do so, than the money that it was delivered to you for a security deposit and for a rental paid in advance.
May I ask a question? Is there anything legal that says that the agency has to give that deposit to the owner?
No,
I know
no.
sometimes deposits in Guadalajara are given to the seller, but that doesn't make sense to me either.
Well, the deposits to the seller are different things that the things we're discussing right now.
Oh, I know, but I mean, is there a law that says that
No.
security deposit should be given to the landlord and not held by the agency?
Well, you can hold the security deposit as a matter of protection to the tenant. It depends if the owner accepts to do that. It's okay. It could be a good way to act as an escrow for
Yeah.
lease for lease operations, right? I haven't seen that. It could be a good thing, like the way Vanessa Hill was explaining us, that the owners they don't have this common practice of returning back the security deposit. So, I mean, if the question is, can a realty agency hold the deposit? I think yes, they can. long as the owner accepts to do that, and not and try it or be very straight to know what is the commission, what is the deposit, and what is the payment. Because then later the owners think that the commission was the security deposit that was given up front, and they sometimes they confuse and want that the realty reimburse the money when the money that the realty charge was the commission. Am I being clear with this idea?
Yeah, I understand what you're saying, but the reality of all of this is, as we were saying earlier, that a lot of landlords don't want to give the money back. But I mean, the concept is the same, that you don't give the deposit to the seller, because what happens if he goes and spends it and the sale doesn't happen, or he doesn't perform, or whatever? I mean, isn't it the role now that we are being protected, and Profeco is protecting the customer, the client? Shouldn't we have some say in where that money goes, so that people who are renting are not held to ransom at the end? And, you know, I see it on Facebook all the time. Oh, we never got our deposit back. Oh, we never got our deposit back. Oh, we never got our deposit back. And, you know, you guys are close to the government or Profeco or whoever makes these decisions. Shouldn't we, as an a group of people who are in business or professionals, shouldn't we be giving this kind of feedback to the government so that we can control this, rather than, oh, it's pot luck whether you get your deposit back or not?
No,
I'm sorry. I think he's talking more when people rent directly without an agency. When people go direct to the owner and it's owner and tenant, there's
Yeah,
not
I
an
get
agency
that,
involved.
but what I
Right? When
read,
the agency is involved, as long as the lease agreement says that the agency is involved, what their commission is going to be, and that they will be holding the deposit, then the company holds the deposit, and then
yeah,
the renters are protected. So it's all about what's in the contract and whether they're renting with an agency, or a lot of people
yeah, I don't
like
do rentals,
directly
Dixie,
with the
but
owner, right?
yeah, I don't do rentals, but I read a lot in Facebook apps and
Right.
so on, people
And
complaining
if you
that they're
comment
not
and you
getting
ask
their
those
money back.
people,
Our
right,
office has even been mentioned as being an office that doesn't give the money back, and I don't know whether that's true or not.
That's
But when we're
hilarious.
sitting,
We don't do rentals.
no, but our
that's why,
office, yeah,
I know.
our office does rentals. And I have seen on Facebook and other social media that particular office where I work being mentioned as being one of the offices that doesn't give the money back. And
then maybe they need to figure it out. I mean,
sorry,
but overall, I said majority of the people who are complaining they don't get their deposit back, like Vanessa said, they don't go, they're not, haven't gone through a company, and
right.
the owner
Well,
then
you've got the tax law to help you there, I guess, haven't you? Yeah.
But
Yes,
it
you
is
will
with
have the tax to
agencies
help.
as well. It is agencies as well. I'm aware of
Yeah.
at least 3 that make a practice
Well-
of not returning them.
Yeah, I've
Well,
read that.
one of the things that I have read is that some of the actual owners have agreed to give back the deposit, and come to find out they thought the deposit went back. And when the people went to fight them on it, was the rental agent that kept their money.
Yeah. Yeah.
Yes.
That's what I've read too, Mitzi. Yeah.
But maybe what you read is a guy from Chapala that we know the name and that he kept the deposit, but that's different. I mean, when following your idea, Alex, if there's any feedback that we could provide to the authorities, the authorities don't care or follow those feedbacks. At the end,
No,
there's
I
a
guess there's
courthouse.
some truth in that. Look, I've had a hotel license for many years and it keeps going up and up and up. I've cancelled it actually, but when I was cancelling it, I was having a discussion with the licensing people in the municipality. And I said, what about all the Airbnbs? Oh, it's too hard for us to follow them up. I said, well, San Miguel follows them up. And in San Miguel, if you've got an Airbnb, you pay tax. If you've got a hotel here, you pay tax. If you've got an Airbnb, you don't. And
No,
you know,
yes, you pay.
you-
In Airbnb, you pay taxes. I mean, I list
well,
on Airbnb
you're
and you
supposed
pay
to pay
taxes.
taxes, but when you talk to the licensing people, they say, oh, it's too hard for us to identify who has an Airbnb, a legal Airbnb, and who doesn't. So,
Well,
you know,
I mean,
it's
the Airbnb is the platform. If you're
Yeah.
talking about listing your property as the way it is on Airbnb without using Airbnb,
That's
I mean, Airbnb it's the name, but
yeah.
the rule of Airbnb, it is a lodging service, and there's a big difference between a lodging service than a lease contract. I mean, I'm going to try.
Oh,
Okay,
I
I'm gonna.
understand that, but I'm talking more about the principle. You know, in Mexico, we're getting much more organized. We're getting computerized. We are picking up. I mean, all of real estate is a big tax income for the government. So
Yes.
all I'm saying is when you look at all of these little bits of it, there are so many areas where they're not controlled and they're not standardized. And so here we are in a business, professional business that is being controlled to as far as they can imagine at the moment, where you're paying taxes on properties that it's not a capital gains tax, it's a wealth tax. It's not returning, the question is not returning the deposit, it's who's stealing that money. And I find it really frustrating. I've only been here 20 years, but you know, I find it so frustrating that when we're starting to get organized, there are all these different little areas that are too hard.
Yes.
So
What
there
I
you go.
think.
I've said my bit.
Yes, what I think is a very good practice, just the way that you have a WhatsApp forum or chat where if you want to rent to a person, you just say the name. Has anybody had a good or bad experience? It could be also be the same way to ask if an owner refunds the deposit, so that you know since the very beginning what can you expect if to rent the property, knowing that she won't refund the money, so that you can deduct it from the last month. I mean, it depends on what side are you. I have seen both sizes, both either the owner or the tenant. And here in Guadalajara, it's very common that the tenant has liability, not liability, sorry, leverage
Yeah, with
upon
that,
the
yeah.
owner,
Yeah.
the owner, because at the end he has the possession. It is
Yeah.
different there with you, because since okay, I'm gonna give you an example. A person who comes from either out of Mexico, a foreigner, he comes, he doesn't have any assets here in Mexico, then you won't ask him for a warrantor for the property, so he's just obligated to pay each month, right? So he can at the end by himself say, I won't pay you the rent and you will deduct it from my deposit. And the owner can say, no, the deposit is deposit and that has to be returned after the contract. And the tenant can say, well, I don't want to do it that way. If I don't want to do it that way, I'm just gonna continue my contract, and at the end, I'm just going to give you my the property. The owner
And
can
this is
do
why
much.
you've got a job.
The owner can do much because at the end he has the possession.
Yeah.
If it is kind of, it depends the way you throw your cards. I have
Oh,
seen
I
both
know, but
sizes.
there's so many discrepancies. That's the kind of you know, I've never rented here, so I guess I would be the landlady if I was involved, but I'm not. But I just I hear clients talk about it. I read it on social media, and we as I think an above board profession are being controlled, but all of these other little things, and maybe that will come, but maybe all these other little things like tax avoidance and cash economy and don't give them their money back and so on is still around, a lot of it. So it's a bit like a hurdle. You just have to get through all the hurdles to survive in Mexico.
Yes, and what I think a good practice will be, well, me as mediator, I have been involved. I'm always trying ahead of time, preventing that the owner keeps the deposit, or trying to guarantee that the tenant delivers the property in good shape. Most of the time, I try to get the mediation before ending the contract, so that 1 month ahead of the lapse of the contract, set a meeting and try to set for both parties some obligations. Okay, you're gonna give the property in 1 month, and the owner wants to inspect the property to see that everything is fine, so that by the time that you vacate the property, the owner doesn't have to retain the security
your money.
deposit so
Yeah.
long. So let's go see the property, do a walkthrough to the property, check for the services ahead of the final date that I'm gonna deliver the property, to see that all the services are being paid, or the electricity bill has been canceled, the internet, every service that it was provided or hired by the tenant. So trying to unify both parties, so that by the time that they deliver the property, in that same way they give them back the security. And that gives both parties the certainty that the property is gonna be returned in good shape, and that the land and the tenant will receive the money immediately. Why? Because most of the time they have to wait 2 or 3 months, so that
Yeah.
any service, any bill doesn't arise later, and they have the excuse to deduct, or just to get less, to discount of the security deposit. So I think that could be a good practice if you want to prevent any conflict ahead of time, maybe 15 days before the lapse of the contract. Try to set a meeting, walk through to the property, check that the services, the shape of the property, and get all the evidence, so the money could be returned by the time that they return the property.
Felipe.
Yeah.
Felipe
Yes.
and Alex, one of the things is, I don't do rentals, but I see a lot of contracts, and almost every rental contract says that the owner has to return the deposit within either 60 or 90 days after the tenant moves out. And that's the problem. That if what he's saying is, if it says the deposit has to be returned the day of, as long as the tenant has canceled all services and paid up, then.
Well, it is not mandatory. It is like a suggestion that I give when you feel frightened that the owner won't give back the security deposit. Most of the
Right.
time, and all of the my contracts also establish that the security deposit will be reimbursed 30 days, not 60 or 90 days. At least the ones that I draw up establish 30 days. But when I see conflict that might arise in the future, I try to prevent them by establishing or trying to negotiate between the parties that if I'm gonna give you the property, make sure that the property, it is in the good conditions that you want to receive it. That's why I do the walkthrough and inspection. So if there's any humidity or something in the wall, or it was not painted the way that I want to be painted, or anything, I try to go to prevent any conflict. That's why I do the walkthrough, so that they can check that the property is good. All the services are, they don't have any balance due, or at the end, when I return the property, since the electricity bill comes each 2 months, well, I'm gonna
Mhm.
take the measure at the day, go to electricity, to CFE, and give them the measure so that they can give me the exact amount, and I have evidence that I already paid. I mean, try to do everything so that the owner feel warranted, and that you can guarantee that the owner will give you back the deposit and don't hold it up 2 or 3 months more.
So at this point, you are representing both sides?
I have been representing both sides. I mean, talking as a lawyer. When I'm a mediator, I don't take part of any of
No,
both.
I get that. Yeah,
Yes.
yeah, get that. Yeah.
Yes, but I always try to help, to prevent the conflict, and to be very impartial and try to give them possible solution. There are some owners that says no, I will give back the money until 30 or 60 days later. Well, if that's the case, either
least you know
accepted
upfront.
or yes, at least you know upfront.
Mhm.
Felipe, isn't
Yes.
it true that in Guadalajara, when you rent, you have to guarantee your rent payment by another property? We had to provide the first page of a deed, and it wasn't even in our name, but we had to find a guarantee in order to rent something in Guadalajara. We don't do that here.
Wow.
Yes. Oh, a very, very, very good question. Yes, here in Guadalajara, most of the good practices from the realties are that you need a tenant screening, maybe an ADR contract, 1 month of rent, one security deposit, and a warrantor that warrants with a property. And they have to give the deed of the prop. Well, when I say give, it's not like giving you, just providing the details with the folio real, with the folio of the property file in the public registry, so that you can see that the property doesn't have any lien or any encumbrances, and with that property you can warrant the obligations of the tenant.
Yeah, I think
Yes.
the bottom line is to have a good contract, and be very specific about how it's going to go, because people move in and they're there for a year, 2 years, sometimes 3 years. So sometimes at the end, it's like, well, you were supposed to pay for that and you never did. And it's a lot of back and forth of what kind of condition it's in, normal wear and tear. And so I think the key for rentals is a good contract. I saw one that said you have 5 days to notify the landlord of anything that doesn't work. Because when you walk in, no one plugs in the toaster, no one checks the microwave, no one makes sure the washing machine goes through a cycle. And so as you start living there, then you find out, oh God, this thing doesn't even work. So I think you need a good contract on both sides. So
Yeah.
then that's the
Yes.
bottom.
In,
You know who
in fact, the ADR contracts that I drew up are always to try to be even for both parties. At the end, here in Guadalajara, we are very restricted with the person who I'm gonna rent him, because at the end, imagine the owner has maybe a 200 USD property hold on a tenant. So his investment, it is set on a person who will be renting the property. And the only obligation of the tenant will be to use the property the way they established that it was going to use. To live in the property, the person who said that they were going to live and not come with 30 people to live there. To take care of the property, to pay in the time, in the place, and in the way that they have. I mean, there are some obligations to the tenant that had to fulfill, but at the end, the tenant doesn't lose anything because there's not any investment on the tenant, a difference to the owner that he has maybe his life savings on that property. That's why owners here in Guadalajara are very put too many conditions to rent a property, because at the end his entire money is invested on that property. So at the end, even when you do a contract that it is better beneficial to the landlord, when you go to court, you can establish that you have just 5 days to report any damage, or if the tenant doesn't pay, he will pay interest for each day, and you can put the interest 10% each day. At the end, if you go to court, the judge won't grant that and will lower the interest. But who wants to go to court? That's why owners try always here in Guadalajara to mediate the matter, so that at the end, what they want to focus on is to receive back the property, and in the meantime, to receive the more money out of the contract that they have just signed. Did I explain myself?
Yeah.
Yes.
And what I
And, you know,
see.
Felipe, oh, sorry. But when
No, continue.
we rented an apartment for our daughter in Guadalajara when she went to college, to the university. And they would only rent it to us if we provided them a deed to our property, and they actually put a hipoteca, a lien, an embargo on our house.
Well,
No, but
until-
they cannot put a lien. They cannot. The contract just established that you warrant with that property.
But they did put in the notation in the public registry's office. And when the lease was over, we had to get the letter from them to release that notation against our house once that we gave the apartment back and it was over. So they had total control. In this
But how
case,
do you know? How do you know that it was a note in the public registry? I mean,
because I requested a no lien certificate to see if there was anything, and there was. They had put a note on it. So some of the owners, I mean, they're pretty.
for how long did
strict.
you rent the property?
For a year, 1 year. Now they did release it when we gave the apartment back. And we did get a letter. They did release it, but they had it held to guarantee they were going to get their rent. We had no guarantee we were going to get our deposit back, but they definitely had guarantee that they were going to get their rent. So it can work either way. Tenants have possession. Yeah, we had possession, but they also had control of my house. So yeah, contracts are so important, I guess.
Yes. It's very important to have a good contract, and this contract helps either persons. I still thinking that what they this note, it could be maybe just like a note that the property will be warranted with this property, but it is not a lien or any restriction, because in order for them to put any restriction on your property, should have gone to court, and you cannot go to court without any dispute. And what will be the dispute if there was a?
It might have just been, but there was a notation on me, in the registry's office. So they did go to that extreme, that the registry's office was notified. Anyway, but it all worked out fine. Obviously, we paid the rent, we gave it back the apartment, we did get our deposit, but they did go to that extreme.
Okay. When we're talking about contract, most of the time contracts, or it is regulated in the law of Jalisco, that not contract has to be more. When talking about residential purposes, it cannot be elevated to a more than 50 years contract. When it is when the contract it is elevated to more than 5 years, is when you have to file in the public registry. Talking about residential purposes. When we talk about commercial purposes, the contract cannot be elevated more than 20 years. And if the contract it is elevated to 6 years rental, should be also filed on the public registry. And for industrial purposes, when I say industrial means like a warehouse or that kind of commercial purposes, you can the most time that you can elevate a contract is 25 years. Also requires, if you sign for industrial purposes, you will have to register if it's elevated for more than 6 years.
Felipe, I have a question. This is Wenda.
Yes.
On the commercial
Wenda.
side, what is the options included in that, lease options in the years, or would that start as a new lease?
For what
So
purpose?
someone may rent a property for 10 years and they have a 10-year option.
At the end, it is just a 10 years. The other 10 years option will be a renew of the contract. But since the very beginning, the duration or the period was established for 10 years.
Okay.
Perfect. There's also when we're talking to contract to residential purposes, here, I'm gonna explain it about here in Guadalajara. You don't see often properties lower price than 1 million pesos in Ajijic. I mean, there's a law. I'm gonna return to this. If you see here, it says habitacional. Habitacional means residential purposes, and it is saying about what's the minimum contract that you can sign for residential purposes. And the Article 2041 from the Civil Code established that the properties that are not up to the amount of about 1 million pesos cannot be the contract elevated less than 1 year for the owner. That means that means that the tenant can be there in the property for as long as he wants to. And let me say it again. If the property worth more than 1 million pesos, when we're talking to residential purposes, the contract, if it worth less than 1 million, you cannot sign a contract for less than 1 year. It has to be at least 1 year. It is mandatory for the owner. And you cannot enforce the tenant to be there for more than 1 year. So the tenant has the power to just stay the time that he wants to stay. If the property worth more than 1 million pesos, you can sign contracts, lease contract for residential purposes for any period of time, not more than 15 years. Did I explain myself?
See.
Okay. Why am I telling you this? Because you cannot enforce a tenant to stay more time than the time that he wants to be in the property. When you're talking about a residential purpose that is going to be rented for this matter, and that the property doesn't worth more than 1 million pesos. It is not about 1 million pesos. It's about 10,000 UMAS. UMAS means like UMA means unidad de medida de actualización, like a current measure of unit. It is a calculation that the government established for this UMA, and 1 UMA is equals to 108 pesos times 10,000. That's why I'm telling you that it is about 1 million pesos. Make sure that when your contract is going to be finished, to sign a new contract, because you just have 30 days when the contract elapses to sign a new one. If you don't sign a new one, then you have to request through the court to vacate the property. Otherwise, if you don't claim in court this matter, the contract just turns indefinite. Indefinite means a temporal. It doesn't have a time for the owner or the tenant to be in the property. It is just indefinite. When this happens, it doesn't mean that the tenant can be in the property as long as he wants. It means that since the contract doesn't have again time or a period of time, you have to request through court so that the tenant vacate the property, and you have to give him a notice of 3 months ahead of the vacation, the vacate of the property. When the tenant is the one who wants to cancel this indeterminate contract, he has to give a notice to the owner that he's going to vacate the property in 1 month. It is very important for you that when the contract elapses, to demand the vacate and to receive back the property within the 30 days of the termination of the contract. A lodging service, it is a lodging service or a lodging contract. It is a mutual agreement between the hotelier and the guest with the purpose of accommodation services for a specific period of time and for a fixed price. In addition to the lodging, the hotelier may offer additional service, either included in lodging fee or charged separately, depending on what the parties agree upon. I suggest that since you are in a touristic area and that a lot of the properties back in Chapala, in the lakeside, are furnished, instead of renting, lodging the property. By lodging the property, you just obligate yourself to give an accommodation or provide accommodation to the client. So you never transmit the possession of the property. The characteristic of this lodging agreement is it is principal because it stands on its own and it is not a supplement to another contract. It's also bilateral because it involves obligation for both the hotelier and the guest. It's commutative. The benefits are non-unbalanced from the outset. It is consensual. It is valid upon the agreement for both parties, and successive performance, the obligation are carried out over the time. The lodging agreement may take different forms. It might be limited to personal shelter, or it may be included food or other services. It can be tacit. This tacit means that when the hotelier operates a public establishment intended for lodging, and it can be expressed when it's governed by specific conditions freely agreed upon the parties. The type of lodging agreements are express or tacit. If it is expressed, the party explicitly agree on the terms and conditions. The hotelier publicly offer lodging services, specifying the qualities, the conditions at a fixed price. The express lodging contract must be in writing. If it lacks proper form, the hotelier is responsible for this omission. So make sure that if you sign a lodging service, it has to be written. A tacit lodging agreement, it is tacit when there is no formal agreement between the parties defining the lodging condition. The conduct of both hotelier and the guest clearly implies a lodging relationship. The properties habitually used for lodging purpose, but not conditional publicly advertised. What are the essential elements of an express lodging agreement? The name of the hotelier, name of the guest, the domicile of the both parties, the guest place of origin, duration of the lodging contract, the agreed price, the characteristic of the room or the house or the property that is where you're going to provide the service of the accommodation, what are the services included on the price, the optional service available, and the signatures of the parties involved. I think that since you live or you provide services in a touristic area and which properties are furnished, I think it's better for you to sign lodging agreements rather than a contract. Why? Because if at the end the rental, the contract of the property that you're gonna rent, it is already furnished, I will suggest instead of going through rental, go through lodging. In lodging, you just provide an accommodation. In the rental, you're granting the transmission of a possession for a period of time. So if any conflict between the parties arises in the future, that doesn't empower you to take back the property. You have to do it through court. If you do an accommodation service, just like a hotel, if the tenant, which is not, it is not defined as tenant, but it is defined as a client or as a guest, you can take the property where you were providing the service if they don't fulfill the contract or don't pay you the fixed price that was agreed. Do you understand this differential between one and the other?
Hi, this is Christina. That's really good information, Felipe. Thank you.
Hi, Christina. Of course it is. If you do rentals, what I'm suggesting is instead of renting a property where you're gonna be involved, giving possession or transmitting the property, if for any reason the tenant don't pay, that doesn't give you the possibility to take out the property or evict them without a declaration of a judge establishing to recover the property.
Okay.
In the lodging service, since you didn't grant the property, you just were obligated to provide an accommodation, you never compromised the possession of the property. You just were obligated to provide an accommodation for a fixed price and with some obligations from you to provide service. You could include the electricity, the water, the internet. So if for any reason the guest doesn't pay, then it gives you the possibility to just take the property, change the key, and without any eviction process, you just restrict the person to enter into the property and you can recover back the possession of the property.
I know
Why
that
is so?
contracts have to be in Spanish in order to be legal here. What is the legal term for lodging instead of renting?
In Spanish, what is the name? Hospedaje.
Yeah. Say that one more
Hospedaje.
time. Hospedaje.
Hospedaje.
Okay.
Hospedaje.
Muy bien.
Hospedaje means
Okay.
lodging. Accommodation means alojamiento, which is the same. There are just synonyms.
Okay. So either one of those is better than renting.
Yes.
Okay.
And when you rent a property, you have to have either to be legitimate or legitimized to do so. In a lodging service, since you're not granting or compromising the property, anybody can provide this service. So there's
Okay.
not involved the property, it is you are you are obligating yourself to just provide a service. It is a very big, I mean, it is quite similar, the figure of the lodging with the rental, because both are for a person to stay there for residential purposes. But the difference is that the lodging service is a render of a professional service, and the other, it is a contract that involves the transmitting of the possession of the property.
Okay,
In
that
this
makes sense.
lodging service, it has to be on writing, so that it is clear for both parties that the usage of the property is for accommodation purposes.
Okay. It's the same in terms of their tax structure, but it protects the owner of the property more, correct?
Say it again, please.
Está el mismo para los impuestos, pero todavía está protegiendo más al dueño de la casa que
Yes.
el otro. Yeah.
Yes, I mean, either in the rental or the lodging, you have paid taxes. It is different because in the lodging service, you have to pay other taxes than the IRS, the ISR. When you rent a property, the IVA, the VAT, the value added
Yeah.
to the property in residential purposes, you don't have to pay IVA in residential purposes. But in the lodging, yes. But I mean, at the end, you have better benefits in a lodging contract when it comes to eviction, rather than in the rental agreement.
Yeah. Okay. And you can help with that, right?
Yes, I can help with that. For both things, you can sign it for both contracts. You can sign it with the ADR process. But what I think is, in the lodging service, you can you're gonna save time and money by signing this contract, because you don't have to go to court. So it
Okay.
is better for the owners to empower them to recover the property without going to trial.
Okay. Sounds good.
However, I think with a lodging service, not only do you have to have all of that paperwork, but you also have to be licensed and inspected by the bomberos and things like that. So it's if we're talking about possession, yeah, that's true. But if we're actually talking about hotels and lodging services, there's a whole other aspect to it as well.
Yes, well, it depends, because if you assimilate this, what you're talking about, as a hotel, I mean, if it's a public establishment that you see it like a B&B or Airbnb or a hotel, well, yes, you need to have permissions, license, touristic permits. But when we're talking about a civil or common, okay, let's suppose that you own a property in Chapala or in Mazamitla, and you want to provide a service to a friend or to a person who wants to just to spend the weekend there. I mean, at the end, you're not
No,
compromising
you're not running
the
a business. Yeah.
Yes, you're not running a business. It is just
Yeah.
like something spontaneous. So
Yeah.
since it is something spontaneous, like just to pay the HOA of the property in Mazamitla, and that way you will help yourself by lodging this property, so
Yeah,
that you
that's
can pay.
different.
I mean,
Yeah.
so it is not involved permits and license. So, and most of the people back in Lakeside, when they rent the property, they don't use it. Well, talking about renting or lodging the property, they don't use it trying to get money
No, they're
speculating.
not. Yeah.
It's more of a maintenance matter that the property remains in the same condition or a better condition. So if you don't want to compromise the possession of the property, then my
Yeah.
suggestion is lodge the property. It will
Yeah.
save money. It is faster. It is better, and you don't have to request also for a warrantor. You just and you can sign promissory notes. You can request for promissory notes to the guest so that he can warranty the furnish and all the mobiliarity that is contained in the property, such as arts and TVs and modern furniture, etc. Okay, so a difference and similarities from the lodging and the rental is both have uh, both share an address. There's a guest in the contract. Rental contract is a tenant. The name of the hotelier, and in the tenant in the renting, it will be the owner or the landlord. This contract of lodging has to have also the origin of the guest, the duration of the lodging service. In the duration of the lodging service, the civil code doesn't establish a minimum or a maximum. So therefore, you can sign a contract for lodging service of just the weekend. And look at this. If you rent a property for a weekend, at the end, you're compromising the property just for 3 days, let's say for the weekend. And if the weekend has already gone through and the tenant doesn't give you back the possession, you will have to go to court to recover the possession. In the lodging service, doesn't work that way. Also, what it has to be contained on the contract for the lodging service, the fixed price, the characteristics or the usage or what you're gonna be providing for the lodging service. Any additions for the contract or what it's included on the contract, and the signs of the parties, either the hotelier and the guest. Always it requires to be on writing, because if you don't have it on writing, the other person, let's say the guest, could allege that the property was rented and not was offering as an accommodation, which is all. If you want to avoid to go to courthouse for this kind of matters, you have to be very specific that you were providing a service, not renting a property. I said that what happened if the lodging service has just elapsed? You just give a notice to the guest that he has to vacate the property or either sign a new contract. If 24 hours later he don't vacate, you can come with the police and evict the person. You can also hold his luggage and his personal items until he pays you. It is very different than a rental contract. When the guest remains on the property more time than the time that was stipulated, you have to give this notice, establishing in how many days he has to vacate. If he doesn't do that, then you go with the police, and you can take him out of the property immediately. If there's not any notice, the contract will remain also indefinite. But until you give this notice, you have the possibility to recover the property immediately. Do you have any doubt? We have just finished the presentation. Do you have any doubt about the renting and the rental and the lodging services? Okay, well, thank you for your time, for your patience. I'm sorry because my English is not so fluent. Maybe I have the same accent as Canelo Alvarez, but I'm doing my best. It's my first presentation in a different language, so I hope that everything was fine.
You did
I'm
very well.
Thank you.
Thank you very
Great.
much.
Thank you.
Excellent.
Hopeful. I'm glad that you at least have a different idea, or that I provide you a new idea for doing these kinds of real estate transactions, such as rental or lodging services.
Yeah, you did a great job. Thank you so much.
Thank you.
Really
Yep,
appreciate
your
it.
English is perfect. Thank you so much.
Thank you so much.
Yes,
Really
thank you,
informative.
thank you,
Thank you.
Thanks.
Thank you, you too. My
Thank
pleasure.
you.
There is his information. Also, I will give you his contact by the WhatsApp group. Thanks a lot, Felipe. It was amazing.
Thanks, everyone.
Excellent. Gracias.